Good afternoon. Thank you for joining Mayor Brown's Global Financial Markets teleconference series. Today's call is entitled The CFPB and Seila Law, What Comes Next? My name is Ori Lev, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of the Consumer Financial Services Group. My practice focuses primarily on representing financial institutions and other companies in government enforcement matters, internal investigations, and litigation, and providing regulatory advice and counsel on federal consumer financial and economic sanctions law. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com and we will respond promptly. This is the same email address on your invitation email. Joining me today is my colleague Stephanie Robinson. Stephanie is also a partner in Mayor Brown's Washington, D.C. office and a member of the Consumer Financial Services Group. Her practice focuses primarily on representing financial institutions and other companies in government enforcement matters and providing regulatory advice and counsel on consumer financial law. With those brief introductions, we will now begin today's discussion. Today's call is going to address the Supreme Court's recent decision in Seila Law and its implications for the CFPB and other agencies. We'll start with a discussion of the decision itself and then move on to discussing what the decision means in practical terms. I started working at the CFPB in the fall of 2010, shortly after the Dodd-Frank Act was passed in July of that year. And from those very first days, the agency was under attack, with claims that it was unconstitutional for a variety of reasons. Nearly 10 years to the day after the act was passed, the Supreme Court finally settled this existential question. The short version of the court's holding is straightforward. The for-cause removal protection that the statute provides the CFPB director is unconstitutional. But that provision is severable from the rest of the statute. Accordingly, in the Supreme Court's words, quote, the agency may continue to operate, but its director must be removable by the president at will. The crux of the issue before the Supreme Court related to what is commonly referred to as for-cause removal. That's the provision of the Dodd-Frank Act, which established the CFPB, that provided that the director of the agency is to serve a 5-year term and is removable by the president before the end of her term only for, quote, inefficiency, neglect of duty, or malfeasance in office, end quote. That is the same protection afforded to FTC commissioners and other members of independent agencies. Indeed, that is the very protection that makes an agency independent, as it insulates the head or heads of the agency from the president's direct authority. Independent agencies have been around for over a century, though most of them are multi-member commissions that make up the alphabet soup of Washington: the FTC, the SEC, the CFTC, and the granddaddy of them all, the Federal Reserve. Given this history, the constitutionality of the CFPB seemed a non-issue to those of us working at the agency in its early days. Indeed, as I'll discuss, the Supreme Court had upheld the independence of FTC commissioners, and good parts of the Dodd-Frank Act were literally cut and pasted from the FTC Act. The question before the Supreme Court in Seila Law was whether the limitations on the president's removal authority violate constitutional separation of powers principles because they impede a president's ability to ensure, in the Constitution's words, that the laws be faithfully executed. Given the nature of the question, one would expect that a Supreme Court decision considering whether for-cause removal restrictions are constitutional would consider how such restrictions might impact a president's ability to execute the law. But as Justice Kagan noted in her dissent, the majority did no such thing. Instead, the majority opinion in the case, authored by Chief Justice Roberts and joined by the court's 4 other conservative justices, took a different approach. First, the court set forth what it described as the CFPB's potent enforcement powers and its broad rulemaking authority. Next, the court noted what it described as a general rule grounded in the court's precedents that, quote, since 1789, the Constitution has been understood to empower the president to keep executive officers accountable by removing them from office if necessary, end quote. Otherwise, it would be, in the court's words, quote, impossible for the president to take care that the laws be faithfully executed. And indeed, a number of the court's precedents had articulated this view. Having identified this general rule, the court then noted that it had made 2 exceptions to this rule. One in the case of FTC commissioners, and the other in the case of the old independent counsel statute. In the case of Humphrey's executor in 1935, the Supreme Court had upheld an identical for-cause removal provision that protected FTC commissioners from removal. The Seila Law Court distinguished Humphrey's executor based on how the Humphrey's executor court had described the FTC's authority. Specifically, the court noted that Humphrey's executor had described the FTC as a, quote, nonpartisan, quote, panel of experts that exercised, quote, quasi-legislative and quasi-judicial powers and exercised, quote, no part of the executive power. Interestingly, the majority in Seila law recognized that, with the exception of the fact that the FTC is in fact a multi-party, multi-member body, these other descriptions of the FTC were not accurate when written. In a footnote, the majority concedes that the Humphrey's executor court's conclusion that the FTC did not exercise executive power has not withstood the test of time. And in another footnote, the majority curiously notes that perhaps the FTC possessed broader rulemaking, enforcement, and adjudicatory powers than the Humphrey's executor's court appreciated, but that what matters is not the powers that the FTC actually possessed, but only those considered by the court in Humphrey's. This odd head-in-the-sand approach seems designed to avoid having to follow Humphrey's executors and affirm the CFPB's constitutionality on the one hand, and avoid having to overturn Humphrey's executor on the other hand. And indeed, the court found that the CFPB is different in what it deemed to be constitutionally significant ways from the FTC as described in Humphrey's executor. Among other things, the CFPB is led by a single director as opposed to a body of experts, and he is much more than a legislative or judicial aid given his power to promulgate regulations and his enforcement authority. The latter especially the court found to be a quintessentially executive power not considered in Humphrey's executor. Having distinguished Humphrey's executor, the court then discussed the second exception to the general rule that the president must be permitted to remove executive officers at will, the independent counsel statute that was upheld in Morrison v. Olson. Here, the court acknowledged that the criminal power wielded by an independent counsel was indeed an executive power, but it was circumscribed because the independent counsel's remit was limited to alleged wrongdoing by high government officials. It contrasted this limited authority to the CFPB director's, quote, authority to bring the coercive power of the state to bear on millions of private citizens and businesses, end quote. Having found that the CFPB did not fit the mold of the two exceptions where the court had previously permitted for-cause removal provisions, the majority then determined not to create another exception. In this part of the opinion, the majority described the novelty of having an independent agency headed by a single individual as opposed to a multi-member commission or board. Although a few such other agencies exist, including the FHFA, which we will discuss shortly, the court found these examples to be isolated, modern, and contested. In addition to being what the majority deemed a historical anomaly, the majority also viewed the CFPB's single director structure as, quote, incompatible with our constitutional structure by vesting significant governmental powers in the hands of a single individual accountable to no one, end quote. The majority noted that, quote, the director is neither elected by the people nor meaningfully controlled by someone that is. And with no colleagues to persuade and no boss or electorate looking over her shoulder, the director may dictate and enforce policy for a vital segment of the economy affecting millions of Americans. Accordingly, the court held the CFPB structure unconstitutional. The court then turned to the question of remedy. The question before the court arose out of a civil investigative demand issued by the CFPB to Seila Law. When Seila Law refused to comply, the CFPB filed suit to enforce the CID. It was on appeal of an order enforcing the CID that the case reached the Supreme Court. The remedy sought by Seila Law was simple: dismiss the CFPB's enforcement action because it was brought by an unconstitutionally structured agency. The CFPB, on the other hand, which agreed that its structure was unconstitutional, argued that the for-cause removal provision of the statute could be severed or cut out of the statute, leaving the agency both free to operate and free to pursue its case against Seila Law. On this issue, the conservative majority splintered. Chief Justice Roberts, joined by Justices Alito and Kavanaugh, along with the four liberal justices who dissented from the constitutional holding, all agreed with the CFPB that the for-cause removal provision could be severed from the statute. That's what leads to the result that I mentioned earlier, that, quote, the agency may continue to operate, but its director must be removable by the president at will. The result for Seila Law itself is less clear. The Supreme Court declined to dismiss the case against it, instead remanding the case for consideration of two questions. First, whether former acting CFP Director Mick Mulvaney, who, because he was serving in an acting role, was subject to the president's removal authority, had ratified the CFPB's decision to bring the lawsuit against Seila Law, which is what the CFPB claimed. And second, if Mulvaney did ratify that decision, whether that ratification was, quote, legally sufficient to cure the constitutional defect in the original CID. We'll talk more about what ratification means in just a few minutes. With that, I'll turn it over to Stephanie to discuss the concurrences and dissents in the case.
Okay, thanks, Ori. So there are two additional opinions that were filed in this case. One is by Justice Thomas, the other is by Justice Kagan. Justice Thomas filed an opinion that concurred in part and dissented in part, and Justice Gorsuch joined in. On the decision that the CFPB's single director structure is unconstitutional, he agreed, suggesting that independent agencies generally do encroach on presidential power. Unlike the majority, though, Justice Thomas expressly calls for overturning Humphrey's executor as wrongly decided, and he calls for eliminating all independent agencies, which he describes as unaccountable and as exercising vast executive power outside the bounds of our constitutional structure. On the court's remedy, he disagrees with the majority. He questions the Supreme Court's jurisprudence surrounding severability and whether courts have the authority to, quote, excise, erase, alter, or otherwise strike down a statute, unquote. In Justice Thomas's view, the proper remedy in finding a statute unconstitutional is to simply refuse to enforce it in the pending case. So here he would have just dismissed the CFPB's case against Seila Law and not severed the for-cause removal provision. So as a reminder, the severability clause in the Dodd-Frank Act says that if any provision is held to be unconstitutional, then the remainder of the act is not thereby affected. And the majority held that if the director were removable at will by the president, then the constitutional violation would disappear, thus concluding that the removal provision in the Dodd-Frank Act should be severed. Justice Thomas said that the court was taking too aggressive a position on severability by severing a provision when it really wasn't necessary to do so. And he criticized the majority for not actually analyzing the statutory language carefully. So yes, he suggested it is the case that if the director were removable at will, then the constitutional violation disappears. But Justice Thomas's counterpoint is that you could just as well point to a different provision of the statute to make the constitutional violation disappear. If the director lacked executive authority under the statute to seek to enforce a CID, then the constitutional violation at issue goes away as well. So in his view, the majority was choosing which provision to sever based on nothing more than mere speculation as to what the legislature would have preferred. And Justice Thomas expressed concerns about the court's severability doctrine, saying that it's really incumbent on the court to take a close look at its precedents and make sure the court is not exceeding the scope of its judicial power. So his dissent was based on that, coupled with his view that severability really makes no difference to the dispute before the court, which could have been resolved simply by denying the CFPB's petition to enforce the CID. Second, as I mentioned, Justice Kagan also filed an opinion, and her opinion concurs in the judgment with respect to severability, but of course it dissents on the decision that the CFPB structure is unconstitutional. And here, Justices Ginsburg, Breyer, and Sotomayor joined in her opinion. And Justice Kagan said, if you apply the court's longstanding precedent, Humphrey's executor, Morrison, other cases, the answer is clear that including a for-cause standard in the statute that created the CFPB does not violate the Constitution. She noted that Congress has the authority to create executive agencies and has created other independent agencies that have been upheld by the court, and that it is really up to Congress and the president to decide what blend of independence and political control is best for an agency, not the justice system. Her dissent criticized the majority for essentially making up the exceptions that it relied on to distinguish between other agencies in the CFPB. She likened the CFPB's powers to those of the Federal Trade Commission, noting that the two agencies have similar rulemaking and enforcement authority, and that the court has sustained the constitutionality of the FTC and other similar agencies and found that the for-cause protections for the heads of those agencies don't impede the president's ability to perform his own constitutional duties, and so don't breach the separation of powers. Kagan's dissent says that the CFPB wields the same kind of power as these other agencies and that all of their heads receive the same kind of removal protection. So she writes, how could it be that this opinion is a dissent? The CFPB director is very similar in its exercise of powers and removal protections as the heads of other constitutionally permissible agencies. So she notes the fact that the majority is distinguishing between FTC and CFPB based primarily on the fact that one has a single director and the other a multi-member board. And the majority decided that the court's precedent in Morrison didn't apply, as Ori was explaining, because Morrison approved for-cause removal protection for an inferior officer, the independent counsel, who had limited duties and no policymaking or administrative authority. But she argues that analysis in Morrison actually extended far beyond inferior officers, and that there's no support for the idea that the number of people at the head of an agency matters to the constitutional issue. So the decision to apply that Humphrey's executor didn't apply was also incorrect. She argued that the Constitution does not distinguish between single director and multi-member independent agencies. And Justice Kagan criticized the majority's suggestion that a single head is somehow more capable of exercising power than a multi-headed agency, where the majority said a single head is the greater threat because he can wield power unilaterally and without having to persuade colleagues. The dissent argued that the president actually has more control over a single director rather than over multiple commissioners, because a multi-member structure actually reduces accountability to the president, because she suggests that it's harder for him to oversee and to implement or to remove, if necessary, a group when you've got 5 or more commissioners rather than a single director. And in supporting that argument, she cites to a couple of things. There's a Senate committee report and various other studies to support her proposition that it's actually easier to protect a board from political control than to protect a single appointed official. So her view is that Congress, when creating the CFPB, actually brought the agency closer to the president and more exposed to his view than if the CFPB were structured by commission. The dissent concludes with the assertion that the Constitution instructs Congress, not the Supreme Court, to decide on agency design, and that is something that the majority ignores, that division of tasks should be sensible and obvious. And with all of that as background, I'm going to turn it back to you, Ori, to talk about how Seila law is implicating the CFPB's pending enforcement actions.
Thanks, Stephanie. As I noted earlier, the majority in Seila law remanded that case to determine whether Acting Director Mulvaney had ratified that action, and if so, whether such a ratification was legally sufficient. But Seila law is not the only case in which ratification is now an issue. The CFPB has close to 24 enforcement actions that are pending in various stages of litigation. And the question in all of those cases is similar to the one that the court remanded in Seila law. What does the Supreme Court decision mean to those pending cases? Should they be dismissed, or can the now constitutionally structured CFPB simply ratify the filing of the actions and continue to prosecute them? Interestingly, the CFPB has previously faced a similar situation. The Bureau's first director, Richard Cordray, was initially appointed to his position by President Obama by recess appointment. And after the Senate subsequently confirmed Cordray, and in light of questions regarding the legality of the recess appointment, Cordray ratified any and all actions he had taken while serving under the recess appointment by publishing a short statement to that effect in the Federal Register. And the Ninth Circuit subsequently held that Cordray's ratification statement was sufficient for purposes of an enforcement case that had been filed by the agency while he was serving pursuant to his recess appointment. Notwithstanding this precedent, the CFPB has taken a different approach after Seila law. Initially, the CFPB filed a notice of the decision in several pending cases and informed the court that, quote, the Bureau will assess whether formal ratification or other action would be appropriate in this case. Subsequently, the CFPB has filed such formal notices of ratification in at least a dozen pending cases. The notices in each case include a declaration from CFPB Director Kathleen Kraninger indicating that she understands that in light of the decision in Seila law, the President may now remove her from office with or without cause, that she's considered the basis for the Bureau's decision to file the lawsuit at issue, and that she ratifies the decision to file the case. That is, the CFPB is taking a case-by-case approach to ratifying its pending enforcement actions. That said, to date, we're not aware of any case where the CFPB has not ratified its decision to file suit. The mere act of ratification, however, doesn't resolve the issue. In several cases, defendants are challenging the legal validity and import of the ratification. Among other grounds, in several cases, defendants have argued that the ratification can't save the CFPB's action because the statute of limitations for filing the action is run. This argument relies on a line of cases that hold that for a ratification to be effective, the ratifier must have the authority to take the action being ratified at the time of ratification. If the statute of limitations is run on the underlying claims, the argument goes, the CFPB could not now bring suit against the parties. Accordingly, it similarly can't ratify the pending suit. In response, in at least one case, the CFPB has argued that reliance on the statute of limitations is misplaced for two reasons. First, the Bureau argues that if the agency wasn't authorized to bring suit when it was unconstitutionally structured, then the statute of limitations couldn't have run against it during that time. This is particularly so, the CFPB argues, because the statute of limitations for certain actions brought under the Dodd-Frank Act runs from the date that the CFPB discovers the violation as opposed to from the date of the violation. The CFPB was unconstitutionally structured and lacked authority to sue, the argument goes. It also lacked capacity to have discovered the violations. Second, the Bureau has argued that any statute of limitations should be deemed equitably tolled under the circumstances. How these and other arguments surrounding ratification of pending CFPB enforcement actions will play out is unclear, but it does appear that notwithstanding the apparent clarity about the constitutionality of the CFPB's future actions, litigation will continue, at least with respect to pending enforcement actions. In terms of prior enforcement actions, the CFPB has not said anything, and we're unaware of it having taken any action to ratify those past enforcement actions that were resolved either through consent orders or judgments or that were litigated to finality. Nor are we aware of any respondents seeking to reopen such cases in light of Seila law. And with that, I will turn it back to you, Stephanie, to talk about some other ratification issues.
Right, thanks. So since the Seila law decision also is going to call into question the validity of the CFPB's prior regulatory actions during the time it was unconstitutional, so the Bureau decided it needed to take action to officially ratify those prior regulatory actions with the goal of providing some certainty to the financial industry that its rules are still valid despite the Supreme Court decision in Seila. And on July 7th, CFPB issued a ratification to be published in the Federal Register in which they would ratify most of the regulatory actions that the Bureau had taken from January 4th, 2012, which was when the agency's first director was officially appointed, through June 30th, 2020. And without admitting that any of the Bureau's actions would otherwise have been invalid, the Bureau affirmed and ratified, with a few exceptions, all of the amendments to its regulations, its actions in issuing joint regulations with other agencies, its consumer information publications, and a variety of other discrete notices and approvals and determinations and concurrences with other agencies that don't fit neatly into other categories. And in doing so, the Bureau emphasized two things. One, that the director is familiar with the ratified actions, and two, that the director has conducted a further evaluation of all of these past actions for purposes of this ratification, and thereby is making an informed decision to ratify them. The Bureau's decision, it said, is reinforced by the fact that many of the ratified actions have engendered significant reliance interests. So they noted that consumers and the business community, governments, state and local, other individuals and entities have all relied upon the validity of these actions in organizing their activities. And so taking this ratification action is intended to secure those existing reliance interests. As I mentioned, there were a couple of exceptions to the ratifications of rulemakings. The first was the July 2017 arbitration rule, which is out of scope because that rule already has no force or effect. Prior to the compliance date of that rule, Congress passed and the President had signed a joint resolution under the Congressional Review Act that disapproved that rule. And the second exception is the November 2017 payday rule, for which the Bureau had revoked the mandatory underwriting provisions and had already separately ratified the payment provisions. And of course, as we've talked about before, that entire rule is subject to litigation and the compliance date of that rule has been stayed. So while this document covered the CFPB's rulemakings, the Bureau didn't use it as an opportunity to just blanket ratify all of its enforcement actions. And instead, as Ori described, they're considering those on a case-by-case basis, determining whether ratifications of pending enforcement actions are appropriate, and if so, making those ratifications separately. And they did note that, I think they thought about this, they're not ratifying previous actions that they don't think have any legal consequences for the public, and right now they're not ratifying enforcement actions that have been finally resolved. Ori, why don't I turn it back to you to talk about the future of CFPB?
Thanks, Stephanie. Just really want to make 2 points about what the future holds in light of Seila law. First, the most likely and direct impact of the decision on the CFPB's future, other than taking the question of constitutionality off the table, may be felt in January. If Joe Biden is elected president, then it's all but certain that Director Kraninger's tenure will end on or shortly after Inauguration Day, and that a President Biden would nominate a new CFPB director to replace her, just as he would replace cabinet members. That, in turn, could mean a significant policy swing for the agency, including with respect to things like the payday rule and other rulemaking and enforcement activity. Indeed, the whole notion underlying the court's decision was that the agency could not be independent so long as it was headed by a single director and should instead be subject to presidential control and direction. In a somewhat ironic twist, if Biden is successful in the election, then the very decision decried by Democrats and celebrated by Republicans will serve to give a new Democratic administration control over the CFPB and allow it to effectuate its policy priorities. Second, the Supreme Court made clear that its decision, quote, does not foreclose Congress from pursuing alternative responses to the problem. For example, converting the CFPB into a multi-member agency, end quote. On the one hand, the court's decision might be just the impetus that a divided Congress needs to act, as both parties have something to gain from converting the CFPB into a commission like the FTC, as that would blunt the ability of the other party to use the agency to aggressively advance its agenda. On the other hand, whichever party's in the White House has little incentive to act, as converting the agency into a commission would deprive it of its chance to more aggressively make its mark on consumer financial protection policy. For now, given how politically contested the CFPB has been, it seems unlikely that Congress will take the court up on the invitation to change the agency's structure. So that's some thoughts on the future of the CFPB, but other agencies might also be affected by the court's decision. And with that, I'll turn it back to Stephanie.
Yeah, so if we look beyond the CFPB world, I think the next natural question is, what does the Seila law decision mean for other federal agencies? The decision supports the idea that it's okay for agencies with multi-member commissions at their head, like the FTC or the SEC, to have removal protections like those in the Dodd-Frank Act, whereas single director-led agencies with removal only for cause violate the separation of powers and are unconstitutional. And there are at least a few other single director agencies where the director is removable only for cause, including the Social Security Administration, the Office of Special Counsel, and the FHFA, the Federal Housing Finance Administration. And the court's decision in Seila raises serious doubts as to the constitutionality of the FHFA, which similarly is being challenged in court. The FHFA's director, Mark Calabria, issued a statement after the Seila law decision came out saying that that decision does not directly affect the constitutionality of the FHFA. And certainly that's true, but an en banc Fifth Circuit recently held that the FHFA's single director for-cause removal provision under the Housing and Economic Recovery Act of 2008, or HERA, which established the FHFA, is unconstitutional. So HERA created the FHFA in 2008 to oversee the GSEs, Fannie Mae and Freddie Mac. And much like the CFPB, FHFA is headed by a single director who can only be removed for cause by the president and is exempt from the congressional appropriations process, which is something that the court touched on in the Seila matter. This case that was before the Fifth Circuit, Collins v. Secretary Mnuchin, involves a challenge by shareholders of Fannie and Freddie who are seeking to invalidate an amendment to a preferred stock agreement between Treasury and the FHFA. And that's an agreement under which FHFA, as conservator for Fannie and Freddie, requires those entities to pay quarterly dividends to the Treasury. So the en banc Fifth Circuit held that FHFA was unconstitutional, that the remedy for the constitutional violation was to sever HERA's for-cause removal provision, but not to invalidate the amendment to the agreement with Treasury, and that shareholders could bring a direct claim against FHFA challenging the amendment. Both parties petitioned the Supreme Court, and on July 9th, the court granted both petitions for certiorari. Each party presented two questions to the court. Treasury and FHFA have not asked the court to consider the constitutional question. Instead, in opposing the shareholders' petition, they've argued that the Supreme Court's grant of cert in Seila made it unnecessary to grant review of essentially the same question here in FHFA. And their questions instead relate to HERA's succession and anti-injunction clauses. The first question is whether HERA's anti-injunction clause precludes the federal court from setting aside the amendment to the agreement. The anti-injunction clause precludes courts from taking action that would restrain or affect the exercise of powers or functions of the agency as conservator. And the second question is whether HERA's succession clause precludes the shareholders from challenging the amendment. Under the succession clause, FHFA as conservator inherits the shareholders' rights to bring derivative actions on behalf of the enterprises. In contrast, the shareholders, however, have asked the court to consider the constitutionality question. So they've asked the court to look at both whether FHFA's structure violates the separation of powers and whether the courts must set aside a final action that the FHFA took when it was unconstitutionally structured and strike down the statutory provisions that make FHFA independent. So if the court decides to reach the remedies question, its analysis could have implications for the CFPB's ratifications. We could end up with a decision that addresses whether an unconstitutionally structured agency can preserve actions that it undertook while operating unconstitutionally. Again, FHFA's structure has many of the same features as the CFPB. So it's led by a single director, it's an independent agency, the director can only be removed for cause, and it's not funded through the regular congressional appropriations process. The only really obvious distinguishing factor that the court might point to is that this agency doesn't have the regulatory or enforcement authority that's quite comparable to that of the CFPB, which the court did kind of focus on in the Seila opinion. So we don't know what's going to happen here. We're just going to have to wait for this term to play out. But it's certainly the decision here in this Collins v. Mnuchin case could certainly have implications for the CFPB and potentially other agencies. And with that, I think we've completed our remarks for today. So I'll just turn it up to Ori to wrap up for us.
Thanks, Stephanie, and thank you to our audience for tuning in. 2 brief reminders. You will receive an email with a link to the recording of today's call, and the recording will also be available as a podcast on your preferred podcast platform. And lastly, as mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. Thank you again for your participation. You may all now disconnect.